Drink and drug driving charges are considered very seriously by the courts. A conviction can be life-changing. Other than a criminal conviction, which can affect future employment prospects and travel, the courts can impose significant fines and licence disqualification, which can affect current employment and lifestyle. People are often surprised that you can be imprisoned for drink driving offences. In fact, hundreds of people each year are sentenced to jail for repeated drink driving offences. One of the reasons is, drink driving is considered to be a very common offence, and magistrates and judges will impose terms of imprisonment as a deterrent message to others in the community. Defending a drink driving charge can mean that the impact on your life, livelihood and loved ones is as minimal as possible. Having a lawyer represent you in court on a drink driving charge can change the outcome of your matter. Firstly, we understand the court process and can help alleviate some of the stress you may be feeling in anticipation of your appearance. Secondly, our experienced lawyers know how to present the evidence and a defence to get you the best possible result. Our job is to provide advice and representation. Our advice addresses whether a client has a possible defence to a charge, and representation at court can involve negotiating charges with police, prosecuting a defence on behalf of the client, or pleading guilty and preparing and presenting the person's case in court. In drink driving cases, avoiding a conviction or licence suspension is possible, but it depends on the circumstances. There are automatic minimum licence suspension periods, and even if a magistrate decides not to register a conviction against you, they're still required to disqualify you for the mandatory licence suspension periods if your reading is .07 or over. Often the important task of your lawyer is trying to keep the magistrate to the minimum licence suspension period. We once had a client who was an 18-year-old man who got into a car accident while under the influence of alcohol. His car was written off during the incident, he had no prior court history and was greatly in need of his licence to be able to start an apprenticeship. We represented the client at the Heidelberg Magistrates Court on the following charges: exceed prescribed concentration of alcohol, careless driving, and fail to have proper control of a motor vehicle. To effectively prepare for the case, we provided guidance to our client as to the necessary documents that must be made available well before the court date. These include counselling letters, certificates, and character references. Our client also penned a letter to the court that clearly showed his remorse, as he expressed how the incident had changed and improved his perspectives. By the court date, we were able to make strong submissions for the client, which persuaded the magistrate to keep the licence penalty to a minimum and to not record a conviction. This was a highly successful outcome and the result of good preparation. To best defend your matter in court, you should entrust your case to an experienced drink driving lawyer. Even when entering a plea of guilty, a defence lawyer can present your circumstances and get you the best possible result.